Good morning. Welcome to GS NEXUS Current Affairs series. As we all know, Supreme Court strikes down rule perpetuating caste-based segregation and discrimination in the prisons. So, in this session, we will discuss about the case as well as the Supreme Court verdicts. Let's first know what was the case. In December 2023, Sukanya Shanta, a journalist, filed a writ petition in the Supreme Court challenging various state prison manuals for perpetuating caste-based division of labor, untouchability, caste-based segregation, and discrimination against denotified tribal communities by labeling them as the habitual offenders, a colonial-era classification. The petition sought the court to declare provisions of the prison manuals and rules as being ultra-vires for violating Article 14, 15, 17, 21, and 23. Now let's know the apex court judgment. The Supreme Court has directed the Union government and states to revise their prison manuals and rules to address caste-based discrimination in prisons. The court noted that existing manuals and rules are violative of Article 14, 15, 17, 21, and 23. Significantly, the court also issued a directive stating that caste columns or any reference to the caste in registers recording under trial or convicted prisoners shall be deleted. Now, let's know what are the further development by the government in this regard. The Union has further been directed to make appropriate changes to the Model Prison Manual 2016 and the Model Prison Consolidation of Service Act 2013 within the next 3 months. The court also decided to take suo motu cognizance of discrimination in prison on any ground such as caste, gender, disability, with the case to be listed in 3 months. According to new rules, prison authority will have to strictly ensure that there is no discrimination, classification, or segregation of prisoners on the basis of their caste. The Ministry of Home Affairs has amended the Model Prison Manual to address the issue of any caste-based discrimination of the inmates in compliance with the Supreme Court verdict. Supreme Court of India, in its judgment of October 2024, directed the Union government and the state to revise their prison manuals and rules to address caste-based discrimination in prison. According to new addition in the manual, the prison authorities will have to strictly ensure that there is no discrimination, classification, or segregation of prisoners on the basis of their caste. It shall be strictly ensured that there is no discrimination of prisoners in allotment of any duty or work in prisons on the basis of their caste. The ministry noted that the provisions of the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act 2013 shall have been binding effects even in prisons and correctional institutions. Now let's see constitutional context. First, Article 14. Article 14 advocated for equality before law and the equal protection of law. The court noted that to ensure equal protection, any classification made by the law must have first, intelligible differentia, which means that there should be a clear distinction between those on whom the law would apply. Second, must have a reasonable relationship between the reason for the differentia and the object to be sought. And third, must not be manifestly arbitrary. Such a situation arises when both the decision-making process and the decision are based on irrelevant facts. It should be noted that the landmark judgment regarding doctrine of arbitrariness was coined by the Supreme Court in Royappa case 1974. Second, Article 15. Article 15 ensures the citizens from any sort of discrimination on the state on the ground of religion, race, caste, sex, or place of birth or any of them. Further, the article itself includes provisions for the advancement of women and children, socio-educationally backward class, scheduled castes, scheduled tribes, and economically weaker sections. Third is Article 16. Article 16 ensures equality of opportunity in matter of public employment and prevents the state from any sort of discrimination on the ground of religion, race, caste, sex, descent, place of birth, residence, or any of them. This article also provides the autonomy to the state to grant special provisions for the backward classes, underrepresented state, SC and STs, EWS for posts under the state. Fourth is Article 17. Article 17 of the Constitution abolished the practice of untouchability. Practice of untouchability is an offence and any doing so is punishable by law. Several laws enacted under Article 17 are: first, Protection of Civil Rights Act 1955; second, Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989; and third, Manual Scavengers and their Rehabilitation Act 2013. Next is Article 21. Article 21, which ensures right to life, has widest amplitude as highlighted in Maneka Gandhi versus Union of India case 1978. The term personal liberty includes in terms of reasonableness and fairness. The court noted that the right to dignity under Article 21 extended even to the incarcerated. Next one is Article 23. Article 23 of Indian Constitution and the Universal Declaration of Human Rights both protected individuals from exploitations and ensures fair treatment in the workplace. The Indian government has enacted laws to address exploitation, including the Immoral Traffic Prohibition Act and the Bonded Labor System Abolition Act. The government is responsible for protecting citizens from exploitation and taking action against perpetrators. The court observed that the assignment of labor based on caste was not voluntary. Hence, the prison manuals perpetrated forced labor prohibition under Article 23. It noted that the Article 23 is informed by the fact that the labor exploitation of Dalit caste is based on their disadvantaged socio-economic status. Now, let's consider some notable facts. First, prisons are a state subject under the state list of 7th schedule of the Constitution of India. Second, the Prisons Act 1894 and the prison manuals of the respective state governments govern the administration of the prison. Third, the Ministry of Home Affairs provides support and guidance to the states and the UTs on various prison administration issues. Fourth is, the Ministry of Home Affairs prepared a Model Prisons and Correctional Service Act in 2023, which covers all the relevant aspects of prison management. The Act includes provisions for reformation, rehabilitation, and integration of prisoners in the society. The last one is Article 30, which deals with the suits and proceedings. It ensures that both the union and the state governments can be held accountable through the legal proceedings. That's all for today. For more such videos, stay tuned to GS Nexus.